Today we ask the question, are you a member of the militia? Often when you see or hear discussions on gun control and the Second Amendment, someone will make the erroneous point that you have to be in the militia to own any sort of firearm. There are two main ways to respond to comments like these. Number one, the individual right to possess a firearm is unconnected with service in a militia. And number two, you may be part of the unorganized militia as defined by federal and state law. This video today, however, is mainly going to focus on point number two, regarding the unorganized militia. So let's start with that first. According to United States federal law, if you are an able-bodied male citizen who is 17 to 44 years old, or if you are a female US citizen who is a member of any US State National Guard, you are a member of the US militia. Congratulations. Yep, right now as you read this, you might already be a member of one of the two classes of militias maintained by the United States. It's just that nobody has bothered to tell you. Today, as defined by the Militia Act of 1903, the term militia is used to describe two classes within the United States. These are the organized militia, consisting of state militia forces, notably the National Guard and Naval Militia, and the unorganized militia, comprising the reserve militia, every able-bodied man of at least 17 and under 45 years of age, not a member of the National Guard or Naval Militia. Check out Title 10, Section 246 of the United States Code. In addition to this federal law, the states added similar language to their own constitutions. Incidentally, this is where Congress derives authority for the draft. Now you say, that settles it. The Constitution allows for roving gangs of men brandishing camouflage pants and fully automatic M16s. Not so fast. There are quite a few nuanced details to talk about. The US Constitution defines how the militia is to be created, organized, and deployed. Section 8 ascribes activation of the militia to the legislative branch. However, less than 10 years after the Constitution was written, the Act of February 28, 1795 delegated the power to call out the militia to the President. The first president, George Washington, then activated the militia to crush the Whiskey Rebellion, and then again during the War of 1812. The act was held as constitutional in Martin v. Mott. Today, a president from either the left or the right could summon what he believes is the militia to crush perceived insurrections. It says right there in the Constitution that the job of the militia is to suppress insurrection. There are at least two landmark Supreme Court cases in the 1800s that confirmed that the militia's answer to the president. Another case established that the president doesn't even need a national emergency to use the National Guard. While the Constitution authorizes Congress to provide for the unorganized militia, it has not done so. The Supreme Court in US v. Miller stated that when called to duty, a member of the unorganized militia must appear with a weapon of his own procurement and of the type in common use at the time. Although the rifles we see today were not the type of weapon in common use when that decision was made, they certainly are now. There are efficiency reasons for those weapons to be basically compatible with the weapons and ammunition the military uses. The unorganized militia would augment the organized militia and military, share ammunition, supply lines, while providing his own weapon. It is for those reasons the assault weapon ban was repealed. But let's go back to the Constitution for a second. Congress currently does nothing to help provide for the unorganized militia as required. Why is that? At the very least, a common use weapon should be tax deductible. Progressives throughout the years have fought back against the idea of an unorganized militia, mainly at the state level. 29 states, seen here colored in orange, have statutes that prohibit groups of people from organizing as private military units without the authorization of the state government. These statutes often specifically prohibit such groups from parading, or drilling in public with firearms. New York's statute here is representative. It applies to groups on both the left and the right. 25 states, shown here in dark color, have statutes that outlaw certain paramilitary activity. These laws make it illegal for individuals to teach others how to use firearms, explosives, or techniques capable of causing injury or death, or to assemble, to train, or practice with such firearms, explosives, or techniques. These state statutes may create felony or misdemeanor offenses, depending on the jurisdiction. These state laws is what stops gangs of unorganized militia from roaming the streets and keeps them contained to their property's rooftop. Other laws come into effect then. Of course, this applies to both the left and the right. As for arguing with people who bring up the militia, you can always go with point number 1, as I mentioned before. The right to bear arms is not conditioned on militia membership, and in fact is not even conditioned on the Second Amendment. But that will be a video for another day.